Good afternoon and welcome to our webinar, Consumer Finance Enforcement Activity in the New Administration. This afternoon we will be talking about what we foresee in the Trump administration in light of some stated changes and what we're actually seeing on the ground in terms of financial services enforcement in the consumer finance space. And I'm fortunate to be joined by three very accomplished guests. Paula-Rose Stark is a former attorney at the Consumer Financial Protection Bureau. She's now with Chambridge Partners, where she's a senior director. Meredith Boylan is a counsel in our practice in the consumer finance practice and is formerly a prosecutor with the New York District Attorney's Office. And Katie Wright has been working extensively really for the last 4 years, helping us build and working on a number of consumer finance matters. And we're happy to have them all here this afternoon. Before we start, I just want to give everybody a few preliminary, housekeeping matters. And first and foremost, I'm Allison Baker. I'm co-chair of the consumer finance practice here at Venable. Before we get started today, we have a note about CLE. CLE will be offered for today's webinar, so please stay tuned until the very end when we will give you the code. Information about the CLE certificate will automatically be sent to attendees after today's session. Please note that our CLE coordinator is out of the office this week, so it may take a couple of weeks to get your CLE certificate. We apologize for that, but nevertheless, you will be receiving it. Also, our webinar today will be recorded and downloadable, and the slides will be available later this week, along with a YouTube of this presentation. At the bottom of your screen, if you're joining us by computer, are multiple application widgets which you can use, and they're called widgets, in fact. They're resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. If at any point during the webinar today you have questions for any of the panelists, please do submit them, and you can submit them through what is called the Q&A widget. We'll try to answer these as we receive them in real time. And if at any point we feel that a fuller answer is needed, we'll follow up with you later by email. And we also, in turn, capture all of the questions that you ask. So feel free to know that and be certain that we will do our very best to answer every question. We also recommend that you use a wired internet connection and close any other programs or browser sessions that are running in the background. And finally, if you are joining us by phone, we ask that you mute your line so that there's no ambient noise. So with all of that having been said, I'd like to introduce our first agenda item, which is something that is, of course, top of everybody's mind, given the political climate in which we're living here in Washington and throughout the country. What is the likely impact of the current political climate on enforcement actions at the federal level and at the state level? And PR, if you can give us some of your thoughts, we'll start with you.
Thank you, Allison, and thank you to all my friends here at Venable for inviting me to join this webinar. It's wonderful to be here, and we're starting with the question I think I've spent more time talking about since November 9th than any other. Obviously, the change in administration poses a lot of uncertainty to folks in consumer finance markets, whether you're new entrants or established players. So what can we say just to start to put some order on the uncertainty and in fact, some of the chaos of what goes with the change in administration? I think the first thing to say is we're probably looking at something that goes well beyond the normal shift of Democratic administration to a Republican administration. Trump's statements, starting with the campaign and certainly since taking office, pose more challenges to sort of the regulatory state, if you will, than I think we've seen in my lifetime. Having said that, now some 100 days in, I think it's not exactly clear what the pose is. Certainly the Consumer Financial Protection Bureau has continued to be a lightning rod for political discourse. We've seen legislation introduced and many variations on talking points come out from both sides. I think it's fair to say at this point that the leadership, both the structure of the leadership as well as the actual personnel of the agency, its regulatory structure, and even the authorities of the CFPB are all in play. Those questions I think will take some time to sort themselves out. Director Cordray is serving a term that ends June of next year. Obviously, in the early days of the administration, there was skirmishing trying to bring a legislation, even with the threat of removing coordinator from office. I think that has receded somewhat. The legislation around restructuring the fundamental workings of the Bureau hasn't moved much further than it did under the Obama administration. I think over a long horizon, I do expect some deals that will alter most likely the budgetary source. So I think it's probably more likely than not, should we continue in a period of Republican dominance on the Hill, that we will see a Republican dominance on the Hill, funding the CFPB coming from the Federal Reserve to congressional appropriation. In time, I think we may also see a shift towards a commission structure at the top of the Bureau and away from a unitary director. Those events, I think, will be the longest to play out and are the most uncertain. In some ways, I think the questions about how CFPB will operate before they get worked out are more important to sort of day-to-day decisions about regulatory compliance and business strategy. From where I stand in all of this, I think you'll see a pronounced shift in how the Bureau operates as well. Under the Obama administration, I think you saw the Bureau really using all of its tools. There were rulemaking, there was active supervision for banks and non-banks, and there was fairly consistent and active enforcement. I think given by Republicans and their sort of willing use of the Congressional Review Act to lock down rulemaking from a variety of agencies, not just the CFPB, I think in the interim period, at least and through the midterms, you are unlikely to see major rulemakings come out of the CFPB. Now, that includes a number of things that were in flight at the time of the election, such as the arbitration rulemaking, the small dollar lending rulemaking, debt collection rulemakings, as well as some sort of stand-up rulemaking, such as the continuation of defining larger participants in certain non-bank markets. For example, I think everyone was expecting a larger participant rulemaking defining the Bureau's supervisory authority as to installment lending. One of the big questions there was sort of how marketplace lenders would fit into that. I think all of those rulemakings will be on ice for a while.
You know, it's interesting because I think some of us who've been watching some of these rules, particularly arbitration, which and small dollar lending, there was a sense that even before the administration changed, there was a lot of opposition to those rules kind of being mounted, both in terms of likely court challenges and just in general in Congress. And I don't really see this administration changing that dynamic too much. Do you?
No, I think that's right. And what's interesting is I think there's sort of volatility and uncertainty in a lot of directions right now in the environment. The Republicans had sort of teed up the prepaid card rulemaking for an early death under the CRA, and it looks right now as if through a combination of forces, that may not happen after all. That rulemaking might actually go into effect. So things that look like they're clear and certain sometimes change quickly in this environment. And in some ways, I think that is the hardest environment to do business in. The other sort of big shift I think we'll see in how the CFPB operates is a change in what issues they take up. I do think they're going to sort of concentrate resources into the tools where they can act behind closed doors and not create as many headlines. So a shift towards supervision, both for banks and non-banks, and in some ways a shift from sort of the front page news that enforcement actions and large fines bring. I think you've also seen them drop rather precipitously some of their more controversial undertakings. The group of actions around disparate impact fair lending problems in the indirect auto space, I think, are now over. Obviously, the Bureau will continue to do fair lending work, and they've signaled that those resources may channel through traditional mortgage fair lending work, as well as a new interest in how fair lending laws and oversight can be applied into the servicing of a whole range of consumer products. So I think that kind of substantive shift is something we're going to see across the board as well. As to enforcement specifically, which I know is the main topic for the day, my own guess is that enforcement actions that originated in supervision will become less frequent. So against major institutions for wide-scale practices, there will be, I think, increased deference to sort of private resolutions. That does mean that the Bureau will give up its ability to levy fines. So that's something to note. As to non-banks and others that are outside the Bureau's supervisory jurisdiction, I think you continue to see enforcement actions for sure. A number have ripened since Trump took office, and in that sense, it does look like business as usual. The thing to watch, and it's hard to do publicly, is what the pipeline looks like. What actions are being initiated now, and do they differ in character from what we've seen over the last 5 years?
It's interesting because I think that, and Katie, I'm going to ask you about this in a minute. There is a sense that, over the last couple of years, the Bureau has brought not only enforcement actions in the context or in certain practices or as to certain industries that you expect and that you would call, without any question, consumer finance or the offering or provision of a consumer financial service or product, but the Bureau has also tested some of the boundaries of its jurisdiction. And I know Katie spent some time thinking about this, and also in your work on some of CFPB matters that we handle as a firm. I'm wondering if you can talk about a couple things. One, how you think interacting, negotiating, and or litigating with or against the CFPB might be different now, if you've noticed a change in the last few months. And two, what your thoughts are about the likelihood that we're going to continue to see some jurisdiction challenging or boundary pushing, for lack of a better way to describe it, enforcement actions. And Meredith and PR, I'd love your thoughts on that as well, but we'll start with you, Katie.
Sure. I want to thank everyone for joining today. I have been battling a pretty intense cold for the past week, and I'm feeling better, but my voice is not recovered yet. So if you have any trouble hearing me, please just shoot a question, and I will literally stand next to the microphone. But to answer your question, Allison, I think the daily interactions and the way that we've been dealing with the Bureau, those things have not changed significantly in the new administration. It's still just as important to, when you get a CID to do all the things that you need to do anyway. You need to act quickly. There are some pretty specific time limits that the Bureau has on changing and narrowing CIDs. And the Bureau, like any regulator, tends to draft their CIDs pretty broadly. So one way that we've really found to help clients is sort of getting the CID earlier and focusing on particularly what the Bureau wants rather than, everything that they ask for. The one thing that I do think may be a bit of a change is while we haven't seen a ton of new investigations, we are sort of seeing the Bureau start to wrap up some of its ongoing long-term investigations. So if you find yourself in the middle of an enforcement action or an investigation, you might want to start preparing yourself for what that resolution looks like. Is it a consent order? Is it a lawsuit? Those are sort of things that we're trying to prepare people for now as the Bureau sort of wraps up the things that are sort of lingering from the old administration.
And Meredith, I'm wondering if you have any thoughts about, given your interactions not just with the Bureau, but more generally with law enforcement, if you think the appetite for challenging or boundary pushing enforcement actions at the federal level, especially with respect to the CFPB, is still there, or if you think that the political climate, it's hard to know, the political climate has maybe tamped down that instinct a little bit.
I think that entities that are being subject to CFPB CIDs and potential enforcement activity, at least for the moment, and certainly in the November to February timeframe, felt somewhat more emboldened, and also taking into consideration some of the activity that we've been seeing at the federal level in the D.C. Circuit Court with respect to the PHH matter. However, I think the pace and the level of confidence that the CFPB was somehow going to just magically disappear has diminished a bit, and reality has reemerged. That said, I think because there is, just by virtue of the fact that the CFPB has been around now for almost 6 years, and there is now a more of a body of litigation that has come out of it, I believe that companies that are subject to enforcement activity do have a little bit more confidence that they can assert in certain positions, whether, indirectly countering an enforcement action or in their negotiations with the CFPB, that there is still a certain amount of lingering uncertainty, I think, within the agency that allows parties to exert some pressure on the agency to wrap up these investigations.
Yeah, I absolutely agree with that. I think it's true both in supervision and enforcement. Anywhere where the applied tools of the bureaus are being used to sort of push companies to adhere to a certain line under various laws and regs. I think it's true in every subset of clients that I've talked to that their willingness and sort of the fervor which they will push back at the agency is at an all-time high. I also think one of the things that will be very interesting to see is sort of the Bureau continues to use UDAP in exams and supervision exams and enforcement litigation. What standards that they're trying to push are actually softened. And here maybe one example might be sort of useful. In a number of contexts, the Bureau sort of challenged firms that were using mailers on advertising that offered sort of pre-selected offers of credit or pre-qualified offers of credit. I think the Bureau was trying to create a standard effectively that if you say to somebody, if you apply for a loan, you've been pre-qualified, they really wanted to look at your application tool and see an approval rate that was at like 85 or 90%. Now, that's a pretty high number. And so in this environment, they may find that the threshold is actually 75 or 80%. And I think UDAP actions will be a particular place to watch for this. Are they asking for less in some ways? I suspect over time we'll see it. That will be something that is only going to be visible after there's sort of a significant intake of new cases and they start to sort of fill out the pipeline. I guess the one other thing I'd add to sort of the prior comments is it's worth sort of highlighting what we think isn't going to change. Since, as Meredith said, the Bureau is now sort of been in operation for 6 years, and as far as I can tell, folks in Washington, D.C. aren't very good at making agencies disappear. No matter what the talk is, things don't usually get shut down here. And I think for me, the biggest thing that is not going to change, there's almost been a profound cultural shift in the regulatory community at the CFPB for sure, but I think more broadly at the prudential regulators, that sort of defending questions from your regulators with process answers alone is not good enough. It wasn't good enough in the first chapter of the CFPB's life, and I don't think it will be good enough going forward. Maybe it's worth sort of pointing out one concrete example of that here. There was a recent sort of OCC report from, I believe it's Inspector General, on the Wells Fargo matter. And one of the many interesting points in that document really focused on sort of early examination contact with the issues that finally ripened to some very big problems. And the OCC found that its examiners actually saw complaints that could have and maybe should have pointed in the direction of the creation of unauthorized consumer accounts. And the examiners, when they talked to the institution about it, had a conversation was about, well, you have a complaint management program. And when a complaint comes in, you do these 5 things. And did you do these 5 things? And sort of the bank was able to satisfy the inquiries on process alone. The clear implication, always in the rearview mirror, things look worse than they are when you're going through them. But the clear implication is that in the current environment, the real question is, what did you do to help these consumers? What did you do to understand whether this is a larger problem? And how did you fix it? And I think that's not going away.
It's interesting. There's 2 points you've touched on. Actually, all 3 of you have touched on that I wanted to just get some more thoughts about. And maybe, Meredith, we can come back to you. One is it strikes me that there's a little bit of a disconnect between the perception of the Bureau's existential likelihood of surviving and its actual survival. And what I mean by that is, there isn't a day that goes by where somebody doesn't ask me, so what do you think? Do you think that if we slow roll this, or do we think that the Bureau is going to go away in its current form? Do we think that the Dodd-Frank Act is going to get eradicated from the earth? The answer to those questions is no. I don't think any of those things is going to happen. And to PR's point, it's very difficult to undo an agency, especially an independent agency, once it's been enacted pursuant to a law. But the perception, which is something Meredith and Katie both talked about, is that people are more likely and willing to push back at the Bureau than perhaps they would have been 2 years ago or even a year ago. And so some of what we see is we see lawsuits that get brought that maybe in a different environment may not have been brought. Or we see people willing to take, push back on in enforcement negotiations or even in supervisory, during supervisory examinations when they may not have otherwise done that, because there's a perception that the Bureau has been weakened by both the political climate but also by some of its losses in court most recently. And I think that perception is interesting because, candidly, I don't think there's actually very much that's changed. And for some of the reasons PR touched on, pardon me, number one, the law enforcement and regulatory regime at the federal level and at the state level, it's still here. And now more than ever, it's focused on consumer protection. And what we've seen in our practice, and Meredith and I in particular can talk about this, is an uptick in state agency action and state law enforcement action, as if somehow there's a concern that the void may need to be filled, even though I'm not sure there is a void. Nevertheless, we see state actors jumping in. And number two, to PR's point, a lot of the federal prudential regulators have also become more, I don't want to say more vigilant than they were, because I think they've always been vigilant, but even increasingly vigilant as it relates to consumer protection issues. And so this regime, the consumer finance protection regime, although spearheaded by the CFPB, is not alone the CFPB's. And it's fair to say that engaging with them and other agencies really shouldn't be very different than it was 4 or 5 months ago. And having said this, Meredith, I'd love for you to talk to us a bit about how you think about, in light of that, clients and would-be clients and companies in the consumer finance space in general should manage risk when they're looking at potential enforcement actions, or even trying to make decisions about taking a product or a service to market and understanding what those regulatory and enforcement risks look like in light of this political climate.
Yeah, it's been a very interesting trend to observe this notion that the CFPB was going to go away and there was going to be a vacuum and the attorney generals were going to step in. It's actually, I think, had, it's an unintended consequence, but we have seen, rather than there being some sort of alleviation or release of pressure on companies from their regulators, that in fact it's like they've doubled down. Now you've got the CFPB and you have states who are preemptively assuming that the CFPB is going to, either go away or they're just going to not care anymore. And so, we've seen both, CFPB investigations and activity coupled with attorneys general parachuting in, providing support. And so, we've seen this, in several spaces, and they're intervening in lawsuits. They are, piggybacking on investigations. There's, multi-state investigations, coupled with CFPB overlay. So, I think as far as the managing risk concept goes, the risk has not gone away, and particular industries they were interested, they were interesting to the regulatory agencies last year, and they still are. And so, when you're operating in certain spaces that touch consumers, lending and so forth, you still have to be proactive and anticipate that you are being watched. People do care. Politicians, still care about consumers, and there isn't going to be, at least, my estimation, some sort of absolution of, or, eradication of regulatory oversight of these industries. And so this is why, we continue to believe that it's in everybody's best interest to keep up with the best practices and keep up with their compliance management systems. And watch the trends, watch what's coming down the pike at the CFP. What are they? What kind of press releases are they putting out? What kind of advisories are they putting out? What are the state attorneys general saying? Because they're still watching companies, and companies should be watching them.
I think there's another sort of way to say effectively the same thing, and it's important to sort of think about where we are in terms of what we know about the history of regulatory cycles and cycles of oversight. Now, obviously, I think all of us would probably agree that the Trump administration will bring a generally lower level of day-to-day oversight, and some of the sort of the activity that we saw in the prior 5 years is unlikely to repeat itself, absolutely. But if you dig a little further and you sort of look at sort of the CFPB enforcement actions from its inception until November 9th, I think you would realize pretty quickly that a lot of the activity that was being called out and the basis for penalties actually occurred in periods of regulatory laxity. And so I think the challenge for firms right now is to understand that, particularly in some markets, the competitive conditions will change. You may very well be a consumer finance executive at a company that has every intention to being a white knight in the marketplace, not just to be good at compliance, but to sort of be truly focused on a fair and responsible sort of customer experience throughout the entire product life cycle. In today's environment, you may be competing against many more firms that don't share those intentions, and that will affect the business decisions that you make. But regulatory liability accrues. So you may not sort of pay for misconduct or sort of problems in sort of your compliance management system today. But to borrow a phrase from Ruth Bader Ginsburg, this country is all about the pendulum, and the pendulum will swing back in the regulatory world. And whether it's the CFPB that's there to sort of call out action, in the next phase of the regulatory cycle, or it's the OCC, or it's the FTC, or it's a state attorney general, somebody will be there to say this wasn't right. And it's a hard balance to strike. And I think, to me, that's what I hear from clients is sort of being, from a strategic perspective, the hardest thing to get right now.
Katie, I was going to ask you to weigh in on some of that.
Sure. Yeah, I was just going to say, one sort of putting a point on what Meredith said, the coordination between the Bureau and the state AGs that we're seeing now, it sort of goes hand in hand with the risk management because there's a lot of sharing of information between all of those entities. So companies need to be really careful with, taking one position with the CFPB, making sure that position is consistent with its other inquiries from state AGs or any other regulators. It's really easy to, sort of have different people handle different issues. But when the regulators are focused on the same thing, it's really important to stay consistent across the board.
And, one of the things I was wondering about, Katie, if you can give us your thoughts on this as well, is this idea of trying to get it right or coming into a situation and cleaning it up, if you will, whether you're a compliance officer or the new owner of a reconstituted business, or you're simply coming in and you're running a business and you're mindful of the regulatory risks. I think that although that's obviously what we recommend you do, it doesn't always get the traction at the CFPB that you would hope it should get. And I'm wondering if you can talk a little bit about how you understand that to play itself out sometimes, and how we think about that when we manage risk.
Sure. So yeah, Allison, you're right. One thing we've seen a lot is sort of, new companies taking over old companies and really sort of paying for the sins of their father. And when it comes to the CFPB, they don't really seem to be moved by that argument. So, I think companies when they decide to make an acquisition, they first need to engage in some pretty intense due diligence, do everything they can to sort of turn over every binder, every paper to sort of see the issues that the regulators could find, and then not to be surprised when regulators come and want to hold them accountable for conduct that took place potentially even before the new company even existed. We don't think it's fair on our end, but it's definitely something that we're seeing. So companies need to be prepared for it. And in terms of the risk management portion, again, it's sort of getting everyone on the same page as soon as possible. beefing up your compliance programs to the extent you can, and really just trying to put your best foot forward at every step along the way, whether it's supervision, enforcement, responding to a CID. It's really just trying to show the Bureau, this is what we've done, this is how we're different, and trying to make the distinctions from potential bad acts that may have happened in the past.
I actually think your reference to mergers and acquisitions is particularly timely. I saw data over the weekend that year to date in 2017, we've already seen more mergers and acquisitions activity than we saw in all of 2016. I think that's going to be true in financial services as well. I think the fintech portion of consumer finance is likely to be particularly affected, but you're going to see it among banks and more established institutions as well. And we've certainly heard from clients that in a way that they've met unexpected regulatory scrutiny in that context. Obviously, if you're a bank and you're making an acquisition of another institution or of a portfolio, your regulator will have something to say about that. And what's interesting is sort of that kind of interface has traditionally been a place where something like the Community Reinvestment Act becomes an issue, and there's a little sort of check on sort of the CRA implications of what acquiring a new branch footprint or a new set of products or a new portfolio is. But now, it's not just a CRA check, it's also a fair lending review. That's a much broader inquiry, and I think firms are not traditionally used to seeing those kinds of questions when they're trying to buy assets or companies. And I think it's a good example of sort of the broader point we're making here, that sort of oversight will continue to be a real force on corporate decision making. It may appear in unexpected or unusual places, but you're still going to be answering many of the same questions you have been over the past few years.
One of the things I think that's noteworthy when you think about acquisition, taking over a consumer finance business or starting a consumer finance business or reconstituting one, is you think to yourself, what are the 4 or 5 places where I need to really be mindful when I manage risk? And, this is a question that all of us get asked with some fair amount of frequency by clients and would-be clients, and just generally speaking. And, one of the things, I have a few thoughts and I have a list that I usually revert to, and I'm curious to get everyone's reaction to it. And the list is in no particular order. I think if you're in a business that services or provides services to what I would call a vulnerable consumer segment, service members, students, senior citizens, perhaps people for whom English isn't a first language, you have a particularly high level of scrutiny you're likely to be susceptible to. You need to be very mindful of that. I think to the extent that every component part of your business that is high consumer touch, it's those places where you need to be very mindful of that risk and be very proactive in managing it. If you run a call center, for example, because you are a lender and you call your consumer clients for whatever reason, whether it is to offer them additional credit or it's to do soft collections of that type, you need to be mindful, for example, of how that call center operates at every single level. So every interaction that your company has with consumers is a very important place to start. If you're in a business where consumers are not necessarily choosing your product or service in the marketplace, rather they're receiving it through not necessarily a choice of their own, such as the debt collection space or any kind of mortgage servicing or loan servicing, student loan servicing, you need to be particularly careful there. The CFPB in particular has noted, and this is true for since 2011, I've heard Director Cordray say this many times, as everyone else has, we're looking very carefully at those businesses because those are industries that consumers haven't selected in the market, which isn't to say that if you're in an industry that they do select, you're exempt from scrutiny. It's just to say that maybe it's heightened if you're in the servicing space, for example. And then another place that I think is really difficult and very hard to manage for lots of reasons has to do with vendor management. In particular, vendors with whom you do business who provide core functions to your company or are involved in high consumer touch component parts of your business, and how well you manage those vendors, how much you know about their business, how much you know about their risk, how much you're able to get a line of sight into how they manage risk is very important for your business. I think of the service provider bulletins that the CFPB has issued. I think of the OCC's vendor management guidelines, which are as strict as they could be. Really important. And so that's the list that I always throw out to people and say, think about these different things, and I'm curious to get reactions. Meredith, what else would you add to that list, or what do you think on that list is particularly important to state or restate when you speak with clients?
Right. I think that I'm honing in on your last bullet point, which is the vendor management. I think in addition to having, comprehensive due diligence of your contract counterparties in these vendor agreements, you have to. It's a constant audit function that has to be performed. You can't just hire a vendor and leave them alone and hope that they're doing the right thing. You have to be in touch with them and making sure that you are managing their services to prevent yourself from getting whacked down the line because, you may try to push blame off on a third party, but the regulators may not see such a clear division and may hold you, will hold you responsible for the missteps that your vendors may be engaging in. And you should also understand how your vendors work, particularly if you do get a CID and you do have to respond to a CID and information is held with your vendors. How do you access that? What are your vendors' document retention policies? Who do you speak to as a vendor to help you collect information in short order? So these are all the types of things you have to be thinking of. Again, this is that proactive, not reactive mindset that you should have when you're susceptible to regulatory oversight.
The one thing I would add, just to the extent that we've been talking about a potential shift at the federal level towards the prudential regulators and consumer protection, vendor management is one of the biggest hooks they have in consumer finance. Their general safety and soundness authority gives them a lot of ways to touch folks who are sort of violating TILA or RESPA along the way, but vendor management has been their main highway for reaching problems in consumer finance, and I think that continues to be the case. I'd add one more to your list, Allison. I also look for businesses where there is sort of disintermediation, if you will, or a disconnect between sort of who the ultimate client is and actual consumers. Now, that certainly picks up on what you said about servicing and the lack of consumer choice in that market, but also products that are sold through brokered models have this issue in strong form as well, where the person who's doing the selling has a short-term sort of incentive that does not necessarily align with long-term customer care. Certainly the matching of consumers to suitable products that they can use and profit from throughout the full life cycle. I think that has probably been the biggest and most important substantive idea that the CFPB has been working on, and you've seen it in ability to repay regulations in various forms, and it certainly flows through their UDAP work as well. So that would be the one that I would add to your list.
Thank you. And how about you, Katie? Any reactions to the list with PR's addition?
Yeah, no, it's a great list. I can't think of anything to add to it, but I will just sort of add to the vulnerable group point. I think we've seen so much enforcement in this space, whether it is for service members or lending, especially in the student lending space. After the whole mortgage bubble, we've heard for years that student lending is the next bubble to burst, and I think the CFPB and the state AGs are really focused on that industry.
I agree. With that in mind, and kind of given this list that we've made, Meredith, when you're advising people, companies, individuals on how to manage crisis, and we should be specific here. We talk about crisis management, and we have a slide up about that. What we're talking about is how you internally and externally manage the response that your clients have, consumers have, the public writ large has, maybe your employees have to a public announcement that there's been an enforcement action, or maybe there's a number of different confidential, non-public enforcement actions brewing that are related. We've seen in recent days, some lawsuits that have resulted in significant drops in market share price, only to have the company go back up. And I wonder how you think about those strategies, especially when you start talking about vulnerable consumer segments or places where you have high consumer touch, or places where you have vendor management issues or products that are sold through brokers, with likely scenarios being that that particular list could generate a high amount of scrutiny and might be the reason why there's an enforcement action.
I mean, fortunately, most of the time, an enforcement action doesn't come out of nowhere. So you will have notice that you are being investigated. You will probably have cooperated in the investigation by providing documents, by perhaps providing witnesses. And so, you do have time to prepare. You also have time to fix your mistakes. And so, as the investigation is going on, you should contemporaneously also be working toward improving your systems, making your compliance more robust, fixing the potential issues that have caught the regulators' attention. And that way, should, unfortunately, there be a lawsuit filed or a settlement reached that results in a public consent order, you have positioned yourself to be able to say with confidence that this was the past. We now remedied this situation. We're moving forward. We have the leadership in place to implement, our very robust policies and, carry on. But you certainly don't want to be, putting your head in the sand and thinking that nothing's going to happen.
One of the observations I have about this, and Katie, I'd love to get your thoughts on this as well in PR. For a long time, it's been the case, and I don't know if it's changing or not. I have a sense it might be a little bit, that there's almost been a taint associated with the fact of a CFPB action, especially a lawsuit. It almost doesn't matter what the lawsuit says or what the allegations are in the complaint. It's the fact of it that seems to have reverberations in the marketplace that are really quite substantial and severe sometimes, not always, but often. And I think part of your crisis management strategy is almost how you deal with that if that happens. And Katie, I'd love your thoughts on that. PR, I'd love your thoughts on that. It's something we see a lot in our space and in our practice.
Sure. Yeah. I mean, I think you're absolutely right. The fact of a lawsuit or the public notice of an investigation, it certainly has just as big of an impact, if not, more of an impact than a final resolution of a lawsuit. One of the things that I think is really important in terms of the crisis management is sort of getting a message quickly and consistently that you can sort of get behind and show, sort of like Meredith was saying, how you've changed, how your behavior is not a problem anymore. It never was. Whatever the message may be, just sort of getting it out there early. But I absolutely agree that the fact of a lawsuit investigation can be just as damaging as going through the entire litigation. And so companies really have to. It sort of drives how you respond to a CID, how you. Whether you settle or whether you agree to a consent order, it'll really drive sort of how you decide to resolve your case.
Let me speak a little more broadly. I think I agree with all of that, but we've gotten some sort of very juicy case studies recently in the corporate world about crisis management and the real challenges in a world where media moves so quickly and is largely uncontrollable by firms. To me, I think the real challenge of managing a crisis, whether it starts with a complaint that blows up on social media or a video that gets posted of an unfortunate interaction, a lawsuit, or allegations in some other form. The challenge for the executive team in a firm that is facing something like that is they have to sort of think strategically, tactically, and be extremely detail-oriented all at once. You have to play a long game and a short game. And I think the two case studies I have in mind of sort of how this can unfold and be very difficult are Uber and United Airlines. The real challenge is sort of whether it's the board or a group of executives making decisions about how to manage something that has bubbled up and is serious. Any individual decision that group might make may be completely justified from a corporate perspective, but play very badly in the broader public arena of public opinion. That's the kind of thing that actually draws enforcement action, sometimes people think regulators have sort of a crystal ball or sort of perfect sort of foresight, but actually think about like the CFPB action in Rush Card. You have a systems meltdown, and then the CFPB goes in and says like, hey, what happened? This is unacceptable. You have to have systems that aren't going to melt down, and they layer on some cost to something that is already very damaging to the company. So how do you sort of protect yourself as a firm about sort of making sure you can see the big picture and try to make the best decisions as you walk through a crisis that really serve long-term interests? And for me, a couple things stand out. Particularly in large places, I think there has to be a clear designation of sort of a group of people who have authority to make decisions. They need to be able to command information internally. In some ways, I think they need to be disciplined about sort of the use of external resources. When something starts to go wrong, a million people start buzzing in your ear, but that doesn't necessarily facilitate sound decision-making. I think the other thing is to sort of be very aggressive about breaking out of the information bubble. You know, it's one thing to sort of say, okay, we have problem X, and we see that there's some UDAP actions that are in our market that look like they apply to this, but actually the hint to how a regulator may look at something may require more creativity than that. Sort of, maybe it's an enforcement action with a product that is nothing like what you offer. Maybe it's from a different industry altogether. Maybe it's not just sort of looking at regulatory actions, but really understanding the market ecosystem of your products. How do consumer advocates sort of feel about what you do? What is the political activity around your product? And really sort of getting all of that into the pipeline to try to make the best decisions you can. In some ways, like when you're at that decision point, it's worth asking, you know, what's the worst version of the story that social media could tell about what I'm about to do? And if that becomes the narrative about my company for the next week, the next month, or the next year, how bad is that for me? And that just gives a little check on sort of the inside baseball problem when inevitably a group of executives start meeting on a problem. Their accumulated wisdom, experience, and industry knowledge will far outstrip that of their consumer. And I think that's the imbalance the CFPB has worked so hard to try to sort of offset. And it's worth sort of making sure that that gets into your boardroom in the sort of hardest moments.
That's a really good point. And, you know, you bring up something interesting when you talk about the CFPB, and I don't know if you have thoughts on this, PR. One of the issues that I think everybody encounters when they settle a matter with the CFPB or there's an enforcement action that becomes a litigation is how you manage their press releases. One of the things that is interesting, and it's a part of the crisis management, and it's particular to the CFPB, although it certainly is an issue for any law enforcement agency, is these press releases that get put out are often written in ways that are not necessarily, you know, they may marry up to the facts as alleged, but they definitely state them in a way that certainly doesn't accord with what a client understands or a respondent or a defendant or their lawyers. And I think that that's part of the crisis management because for example, the CFPB is a great example. Their press releases are very artfully written. They're pretty aggressively written, and they go out to a very broad audience of people, including, you know, the Wall Street Journal, the New York Times, the Washington Post, ABC News, CBS News, CNN, you know, publications and media outlets that everybody hears, listens to, watches. And that's a big part of your crisis management strategy. It has a lot to do with who is the agency bringing the action and how far-reaching their voice is. The CFPB happens to have a particularly far-reaching voice, in part because it's still a relatively new agency, and everything it does gets a lot of public scrutiny. And I'm curious what your thoughts are about that.
Yeah, I also think it's part of the reason the fact of a CFPB lawsuit has weighed so heavily on companies is I think the CFPB made a completely intentional decision to sort of create a sea change in how it interfaces with the media. Hold up a Federal Reserve press release to a CFPB press release, and it's sort of a giggle at this point. Now, I think I can give you the sort of perspective on why CFPB chose what it chose, and I think it certainly sees enforcement activity and everything else that it does as sort of a way to sort of emphasize problems it sees in the marketplace, and it wants to give firms a tangible resource for coming into compliance. And so more detail in a consent order, in a CFPB consent order versus a prudential consent order, more detail in a press release is meant to highlight what they see as the line of good and bad conduct being. Obviously, that has been received very differently by the firms, both the ones that are the subject of the press releases and more generally. I actually think that'll be one of the interesting markers as we see the CFPB go under the leadership of a Trump administration appointee, whether the megaphone gets put away, whether the press releases get walked back and become more conventional vis-a-vis sort of the traditional sort of prudential supervision sort of oversight world. I wouldn't be shocked if it did.
Yeah, I think that's right. You know, besides working at the CFPB, I'm an alum of the Department of Justice, and one of the things we did when I worked there is we would help draft press releases for our lawsuits. And what strikes me as the difference between the DOJ, the Department of Justice, which is obviously a very hard-hitting law enforcement agency, the most hard-hitting in the United States, and the CFPB is that the CFPB's press releases are designed to align with its mission of being a consumer-facing agency. And so some of what it does is designed to affect a deterrence policy along the lines of what PR was saying, and that is very much what the Department of Justice does, is they'll send a press release out about a series of actions that are designed to send a message to the marketplace. Don't you ever think about this because your competitor over here got whacked for it. The CFPB does that, but they're also doing something else. They have their press releases designed to educate consumers and to reach the consumer population in a way that's a little different than I think the prudentials or any federal regulator really, even some state attorneys general, which obviously have that mission as well because they're elected officials. They have a slightly different approach than the CFPB. But I find that in managing crises for clients, the way that the Bureau writes its press releases becomes a topic of conversation constantly. And, you know, you might see a sea change with a new director in the next year or so.
Well, in some ways, it calls to mind, the flap around how CFPB has handled the complaints that came directly to the agency and the publication through the database of the data related to those complaints and then eventually the narratives. We have seen in some of the legislation proposing restructuring of the CFPB, explicit language stripping the CFPB of the ability to sort of publicize that information. I don't think you'll see the same on press releases, but it goes to a similar sort of instinct that the first incarnation of the CFPB has had under sort of Elizabeth Warren for sure, who in some ways is the mother of the press release and public relations strategy of the agency, and Director Cordray. So I do think all of that is going to change a little bit under new leadership.
And this brings us to another topic that I think is particularly interesting, and we touched on it a little bit earlier, which is the role that we see other regulators, particularly state agencies and law enforcement agencies, regulators, playing in the space alongside of the CFPB, but also almost in anticipation that the CFPB may lessen at least its enforcement actions over the next few years. And query as to whether that happens or not, but what we had definitely seen is an uptick in state AG activity, almost an incredible uptick really you can almost trace it to January 20th, which I guess was a Friday, so that next Monday, which I guess was January 23rd, the serious spate of investigations and actions that seem to percolate almost overnight from certain state attorneys general offices is very notable. It's very, very notable, and it's clearly in response to a perceived change in the political climate in D.C. and some concern among those state attorneys general that the CFPB in particular, but also other agencies in the government, the federal agencies, might take a less aggressive role going forward. You touched on this earlier, Meredith, but I'm wondering if you can give us a little bit more of a sense of what you're seeing and really what the impact has been, because I think it's somewhat counterintuitive.
Sure. So what we're seeing is the state attorneys general. I forget who it was among our group here was mentioning some of these consumer advocacy groups. I think that they're taking a lot of cues from the consumer nonprofits and really trying to be receptive to those complaints. I think just another trend that we've seen is politically across the spectrum is that constituents have found their voice, and I think that they're making their concerns known to state attorneys general, many of whom have hotlines, many of whom are soliciting, complaints a la the CFPB as well. And so what we are seeing is not, the state attorneys general have freedom to pursue consumer protection claims, under CFPA, but they also have their own regime of laws that they can choose from. And perhaps that's, a state AG in conjunction with a, state banking regulator to look at licensing and so forth. So, but we have found that many of these state attorneys general, I think also because their bureaucracy is, much more streamlined, they can be very aggressive. They are empowered to take, fairly aggressive action against the companies that they are interested in. They feel, I think, less concerned about their relevance and more emboldened to take a position that maybe is not as influenced by, broader corporate interests. And so we've found that we have some of the cases that we've been working on that are the most active and perhaps have the most consequence to the clients that we serve, and the ones that we read about are state attorneys general actions.
One of the things I think that's very interesting about this is there has been a coalition of state attorneys general who have really taken the CFPB cause up, and I note in particular the PHH case, which everyone's talked about, which is in the D.C. Circuit Court of Appeals here in D.C., obviously, and is being reviewed by the entire court. There was a motion brought by a group of Democratic state attorneys general probably about 5 weeks ago, seeking to intervene essentially on behalf of the Consumer Financial Protection Bureaus, and in particular concerned about the question of how the CFPB structure would ultimately be found on review. And ultimately their motion to intervene was denied on timeliness grounds. But what was interesting about it was there was a lot of discussion about why that motion was brought, but the kind of overwhelming consensus was that the motion was brought in the event that the CFPB loses its bid in front of the D.C. Circuit en banc review and wants to go up to the Supreme Court to appeal that decision, but ultimately can't do that without the Solicitor General of the United States agreeing, because that's how the Dodd-Frank Act is set up, and somehow the state attorneys general being positioned to take up that cause. Who knows? That's prognosticating to some extent, but it seems very plausible. And if you look at some of the actions that have gone on subsequently, both in terms of joining with the CFPB in public actions, but also some of the non-public enforcement actions that you read about, hear about, just kind of know about, it's really no surprise that the state AGs have taken a front line here, given the perception of what's gone on at the federal level. But there's something else I want to note. It's not that new. The CFPB started, and its director, of course, is an alum of the AG world, but even when the CFPB started, the very first year of its existence, there was a lot of work being done with the National Association of Attorneys General, Consumer Protection Working Group, especially with the Enforcement Office at the Bureau, and that has continued. That's definitely continued. But I think that the fact that you see state AGs increasing their presence, increasing their allocation of resources and their devotion of resources to consumer finance issues is very noteworthy and something that we're going to continue to see as the years progress. And PR, I don't know what your view on that is.
A couple of notes, I guess, color commentary. I definitely agree that there's a group of state attorneys general who sort of on November 9th kicked it into high gear. I also agree with you, Allison, that the CFPB has spent years building networks and relationships with those offices, unlike other federal regulators in the banking space, and may now, in terms of the enforcement office of the CFPB, be in a position to provide really material support. At some very practical level, You have some 100 enforcement attorneys who work for the CFPB, and I think if you sort of map out what we've been saying over the last hour in terms of what their workload is likely to look like over the next few years, one way to keep them busy is to engage them in support of state attorneys general offices that have a more open pathway, as Meredith described. I think it may also be helpful just to pause for a second and sort of think a little bit about what those actions might look like. As we've noted on our sort of formal slides, most states have UDAP laws. Under Dodd-Frank, they also have certain ability to sue under Dodd-Frank UDAP. I'd put that high on the list of things that will get restructured if there's finally legislation affecting the CFPB's authorities. And for regulatory nerds like myself, that becomes a pretty interesting question on sort of where the line is drawn in the world of preemption between federal and state law. But don't forget that there are also non-discrimination statutes that might be used in ways that they haven't been, certainly more aggressively. And when you get on the list of sort of other areas where there's a lot of state regulation, one of the real questions I have about the Attorney General litigation that we're likely to see is sort of the experience and capacity of those offices to bring those cases. Now, certainly if you're looking at New York and California, which I think are the lead offices, both by virtue of the firms in their jurisdiction, but their historical activity in consumer protection has been strong for a long time. That's one thing. But as an interesting data point, a number of friends and former colleagues who have landed in various state AG's offices, and not just, I will say, the ones in blue states on our maps, but even in some red state attorney general offices, have called me to talk about how UDAP actions are brought, what federal UDAP law has been used to do, where the boundary lines are on some questions. I have taken that as sort of a newfound interest in all of this that certainly backs up what Meredith had to say. I guess the final point I would add, and I think this is in some ways the least friendly to those among our client base, there's also potential we see an uptick in consumer protection class action lawsuits. Certainly some of our former colleagues work in public interest type firms that might bring those. You still have an active and in some ways enraged plaintiffs bar that will be looking for those opportunities as well. So let's not forget that.
Yeah, that's an excellent point. I want to go back to the state AGs for a moment. There's actually a provision in the Dodd-Frank Act that contemplates the state attorneys general pursuing actions under the Consumer Financial Protection Act's prohibitions against unfair, deceptive, or abusive acts or practices, what we call UDAP with two A's. And so it's clearly contemplated in the structure of the Consumer Financial Protection Act, this relationship between state AGs and the CFPB, and it was done very deliberately because, as many people know, prior to the Dodd-Frank Act, there was a very, and PR touched on it, a very aggressive preemption regime where there was a sense that if you were a nationally chartered bank, you could argue that only the consumer finance laws of the federal laws applied to you and not the state consumer protection laws. And so there was a real concern to, A, embolden and give state AGs and other regulatory agencies an ability to prosecute CFPA cases, but there's also a carve-out in there for nationally chartered banks. So it kind of went a little bit of the way, but not the whole way, from the perspective of certainly the state AG bar. The plaintiff's bar, however, sees itself as kind of stepping in and taking over, perhaps, where the Consumer Financial Protection Act leaves off, which I think was your point.
Yes. Let me add one other point here. In some areas where state law has been dominant, regardless of sort of historical preemption, places like debt collection, I think the change in administration will have enormous impact. I think the lending portions of the consumer finance industry look at the CFPB's burgeoning debt collection rulemaking with some degree of anticipation. Not that it was going to like everything in the rule, but that's an area where having clear, consistent, and nationally applicable standards would have actually brought substantial relief to firms that engage in debt collection. And I think living in a world where what's allowed in that space varies not just state by state, but in some places county by county based on court opinions. That's a very difficult way to run a business, and I think because we're sort of in a regulatory cycle that will sort of emphasize state action, because there's a traditional sort of concern about vulnerable consumers and folks who sort of owe debts are almost always going to be in that case, whether they fit other demographic markers. And because we may also be looking towards a change in where we are in the credit cycle. So, you might see more consumers struggling, more people subject to debt collection. That's an area where I would really look at and sort of for emphasis among the states.
Which leads us to another topic, which is kind of part and parcel of what we've been discussing, which is how we think the new administration or the not so new administration, we're past the 100-day mark, is likely to try to reform not just the CFPB, but more generally maybe the way this space does business. I mean, there's been a lot of discussion about regulatory reform, both at the White House but also in Congress. There have been various iterations of what's called the Choice Act, which is the House Financial Services Committee's piece of legislation that's designed to reform the structure and or operation and or prosecutorial authority of the Consumer Financial Protection Bureau. And in general, there seems to be somewhat of a groundswell of interest in at least rolling back, if not actually significantly diminishing the reach of certain regulations, but also certain enforcement authority. And one of the things I've heard recently within the last 30 days or so is an interest in maybe getting rid of the Consumer Financial Protection Bureau's UDAP authority altogether, not just abusive, which had been discussed for a long time being the new authority, but all UDAP authority. And I'm curious, and I'll start with you, PR, number one, what you hear about that, and this is kind of a parlor game here in D.C. Everyone likes to talk about this. It's what everyone does over drinks. Number one, and number two, what that would mean if UDAP for the CFPB was gotten rid of, and number three, so I don't actually think that's going to happen. Number three, how the specter of that influences or affects business decisions or even the way companies respond to enforcement or supervisory queries.
So it's a very interesting question, and it is a parlor game here. I think it was included in the most recent legislation bouncing around the House. I suspect it won't happen. I think on the things that, on the list of things that Senator Warren and her friends in Congress will go to the mat on, preserving UDAP authority for the CFPB would be pretty high. But if we want to play the game where we assume that does happen, the first thing I would say is other agencies would continue to have UDAP authority, both the Federal Trade Commission and the prudential regulators. Now, they would not have abusiveness. For my own part in that, I've always thought abusiveness was in some sense a red herring. I think there's a little LSAT-style game people play trying to find practices that are abusive but are neither unfair nor deceptive.
It's another parlor game in D.C., yeah.
So we're all big nerds here in D.C., and this is what we do in our free time. I, for one, think there could be things that are abusive but not unfair or deceptive, but what really matters is that the jurisdiction of the other agencies, the FTC and the OCC, the Fed, and the FDIC, would cover almost everything that CFPB UDAP covers. So there would be a question about sort of the degree of cultural change at those places and their willingness to use that authority. I think historically, certainly at the prudential regulators, UDAP authority was not very prominent. The major cases that they brought under their UDAP authority really related to egregious marketing problems. Having said that, I think safety and soundness problems are easier for them to move quickly on, and I think a lot of the problems that they cited and tracked through supervision in subprime lending, in particular prior to the crisis, could have been subject to their UDAP authority, but I think they felt in their internal deliberations in all likelihood that just using general safety and soundness tools was a much more streamlined path to achieving the same result. So I guess that's the first thing I would say. The second thing I would say is, as Meredith pointed out, almost every state, even the sort of deep red ones that we take as a proxy for sort of anti-regulatory jurisdictions have UDAP statutes. They do vary in their scope and the interpretive common law that governs them, but the body of federal law has generally been influential in how those statutes have been interpreted. So even if you strike CFPB's UDAP authority, you have this other sort of pathway to reaching some of those practices.
Yeah, and the other thing I note when you talk about UDAP authority of prudential regulators, it's Section 5 of the Federal Trade Commission Act that the prudential regulators, the OCC, the Federal Reserve, and the FDIC are able to use. And it's interesting because I do think that I don't actually think there's any chance that the UDAP authority of the CFPB is going to go away, but you have a lot of other agencies in the federal and state level who also have that authority, including the Federal Trade Commission, which has a lot of overlapping non-bank authority with the CFPB. So I think the point, of course, is that a lot of the prognostication we read about, a lot of the legislative proposals we hear about, don't really practically change the way companies need to think about risk, need to think about their interactions with consumers, need to think about the appetite that federal and state regulators have for enforcing consumer finance laws. Meredith, I'm curious if you can give us some of your thoughts here, especially along this vein of regardless of what happens, you still need to comply with the law, because I think that that's true. And I think a lot of what we're hearing is kind of some background noise, but doesn't really get to that core issue.
Right. I mean, what clearly the takeaway from our discussion is that there are various avenues that you have exposure if you're not following, the rules and you're not treating consumers well. I also, I do think that the attention that some of these consumer protection cases have received over the last several years has perhaps may inspire agencies that otherwise would not have taken such an interest in UDAP or in these consumer protection type claims to actually step in the event that the CFPB does go away. I also think what we were talking about before with the CFPB's different approach, their more consumer-friendly approach to explaining what the vagaries that they've encountered it's empowered consumers. I mean, it has served its role, and I think as consumers feel empowered, even if there's not a CFPB snooping around or a state AG that's looking at their loan, they feel empowered to reach out and to assert their rights. And so I think that there's been a new cycle where consumers are invested in their own well-being, and even consumers who, may not be the most sophisticated, they read the headlines. They know that some of these, big banks, big companies have been called out for bad behavior, and they can understand that they have, in some cases they have rights that can be protected. And so I think that, there's kind of a new movement afoot, both, consumers engaging in their own self-help, and that then their causes have been taken up by the CFPB and other agencies that, can help them get the relief they need.
I guess I'd amplify that in one way. Unfortunately, I don't have my CFPB enforcement action database in front of me, but if you were to look at all of the enforcement actions in which CFPB used its UDAP authority, I think it's true that in every place where they've used abusiveness, they have also pled a violation of a technical reg, where there's sort of a clear-cut sort of violation of law, such as the telemarketing sales rule, which they did in the first few cases. I think you would also find a high degree of correlation, even under unfairness and deceptiveness, which have much greater definition and bodies of common law associated with them, that they typically plead those in the connection of other regulatory problems. The one thing you haven't heard anybody here say is they think the Truth in Lending Act is going to be repealed, or they think that the Fair Credit Reporting Act is going to be repealed. And so all of the political stuff swirling around the Bureau, whether it's questions about who will lead it or how that leadership will be structured, or whether it has rulemaking authority or UDAP authority, shouldn't obscure the fact that the core consumer mandates that apply to your businesses are not changing in wholesale. Now, over time, the agency may affect sort of what some of the regulations say. There's certainly a potential for deregulatory activity. But that seems to be coming a little bit later. That's sort of, down the road. In terms of sort of operating your business today, all the usual stuff still applies. And the best way to sort of keep yourself on the right side of it is probably doing what you've been doing. And I know Katie mentioned some of it, which is sort of good proactive compliance management. To me, those disciplines don't change. If you get a consumer complaint, you still have to do certain things to run it down, to respond to the consumer, or to look at it from a broader risk management perspective. You still should be doing testing to make sure that your policies and procedures are being followed. You still need to sort of be aware of what legal mandates apply to your business and that they're being reflected in your training and your sort of policies and procedures. Clearly, what will change is sort of the outputs, the information that your compliance system creates may lead to different business decisions in this environment. The competitive conditions in markets has changed, but the day-to-day work of compliance should go on more or less the same.
Yep. And I actually think that the empowered consumer that Meredith was talking about is actually going to sort of serve as an inherent check on any change that a Trump administration might try to make. We know that we will probably have a new director in a year, but, Trump was elected on this anti-establishment, anti-Wall Street mantra, and those are the same goals that the CFPB supports. So I think there is sort of a tension between trying to either get rid of the CFPB or change it substantially and still sort of cater to the same people that got him elected.
It's a really good point, and it takes us to our last kind of area of discussion today, which is really thinking about the future, not just the immediate future, but kind of going forward. And I'll start with you, Katie. You mentioned that, there's a lot of conversation around how long Director Cordray will stay. For those of you who don't know on the phone and who are listening and watching, his term currently ends in July of 2018, so it ends a little bit more than a year from now. There's a lot of discussion. Is he going to go home and run for governor of Ohio? Is he going to otherwise be asked to leave? Is he going to be forced to leave? So far, none of those things has happened. There's no reason to think it will happen for lots of political reasons. Whether he runs for governor or not is obviously not really the scope of our discussion here today. But I do think when we think about the future of consumer financial protection law and this area, we obviously think about the CFPB, but we think about everything. And so, Katie, if you can kind of give us a sense of, if you're looking out over the horizon over the next couple years, what are some of the trends, both substantive trends, but also just more general risk management ideas that you would want clients to adopt and trends that you're mindful of or you expect to see?
So one thing that I would at least hope to see is sort of a narrowing of the Bureau and maybe some other law enforcement agencies' focus and sort of, coming up with coherent policy strategies so that businesses that work in that space can know how to follow the law and, prepare themselves for any issues that may come up. Right now I think there's a lot of uncertainty in a number of industries, including industries that probably never even thought that they would be touched by the CFPB. So one thing that I think, as we see more court cases and more people sort of pushing back against the Bureau's broad interpretation of their authority is sort of to have a narrowing and a more focused platform coming out of the Bureau.
How about you, Meredith?
I'm thinking that, I'd like to see clients really using this time to take a look at their businesses, take a look at their systems, try to think forward, not only for potential, maybe there will be a change at the CFPB that somehow relaxes regulations, but just getting there, to the extent there is any regulatory relaxation, to take this time to actually get their ducks in a row and prepare for the future, because, time moves quickly, regimes change, we don't know what will happen in 3 years and, from now, 3.5 years from now, and so to the extent that, there is any breathing room, which I haven't seen it, but if that's, if anybody on the line is experiencing that, okay, take this time to clean your house, get your house in order, and be well positioned for moving forward.
How about you, PR? What do you think? What are some of the lessons
So I guess
learned?
I have 3 to share. The first is about a topic we probably haven't talked enough about today, which is just innovation. A lot of what's going on in consumer finance is really as much about sort of new technologies, new use of data, as it is about sort of the regulatory revolution that came with Dodd-Frank. And I think the change in administration probably creates some space for that to continue to happen. I think it also will underscore the need that most of my clients will talk about from time to time, which is the updating of the regulatory framework. When you look at something like the Fair Debt Collection Practices Act or the Fair Credit Reporting Act, you really have regulatory regimes that barely address the real business practices of the 90s and the aughts. They are certainly not prepared for a big data machine learning world. And I think there's certainly an advantage for firms that are sort of in the innovation part of this to operate in an environment where there's probably going to be less scrutiny day to day because they will shape the regulatory regime that emerges eventually. That's a very powerful thing. And I talk a lot to clients about sort of being responsible and sort of taking that on. It's certainly pro-growth, and it's good for the companies, and it creates space for innovation. But part of, I think, the post-financial crisis world is, an inclusion of certain norms around business behavior. I don't think that's going to go away. The second one is to say that I think even a pro-corporate, pro-growth environment will bring firms into contact with their regulators, sometimes unexpectedly, and sometimes in those touch points, they will get a lot more heat than they expect. So I think one place people are going to feel the heat are sort of mergers and acquisitions. That may be because you're a bank and you need to get approval from a regulator, but it may also be that private equity firms have internalized some of the lessons of the last regulatory cycle and will simply look for companies to have more sophisticated compliance management. Certainly their banking partners are going to. So that may not go away. The other area that I think people are sort of not paying enough attention to is sort of new product development. Regulators are certainly going to take a hard look there. And so I think both in M&A and in new products, you really want to keep your eye on the fundamentals of compliance, which for me are thoughtful, consumer-centric product and process design. And if you can do that up front, if you can put the consumer experience into the boardroom when you're approving major initiatives, and that's part of how you do risk management day in and day out, wherever we are in the regulatory cycle, you're probably going to be well served. The third one, and I think this is where we're on the cusp of sort of almost a revolution in sort of how compliance is done, is the use of analytics. It's amazing I haven't said this where this is my biggest sort of mantra in my professional life, particularly as to UDAP, that data, wherever you have a UDAP issue, whether it's sort of an internal conversation about a complaint that has come in, or you're on the wrong end of a CID and you're trying to sort of recontextualize a business practice that a regulator has at least one eyebrow up over. Data, data, data. A lot of how you can move the ball with data really is just using information that is already flowing through your firm to run the business. And I think often, particularly in litigation, there is too much reticence to go down that path for fear of creating an incriminating set of information. But I have worked with several clients. I believe this in every cell in my body, that actually using that to your own advantage is probably the most powerful and underused tool that firms have.
Thank you. A few thoughts. I go back to our list from earlier. I don't think that list changes. I do think innovation is definitely likely to swell over the next couple of years, which is a good thing. But I still think you need to be mindful of the following. Are you targeting a vulnerable consumer segment? Look at where your business processes are most consumer touching. Are you in a servicing business? Are you in a broker business? Pardon me. And or are you managing your vendors? And with that, I want to thank all of our participants today. Thank you.